And then we did a Halloween ghost town. We had a gentleman who wrote a book about the ghosts of Chicago, and we started out at Sam Ciennis's place, Billy Ghost, underneath. We started out there on our bus, and we talked about the ghosts of the Billy Goats there. And then we went out to the totem pole at the lake, and then we also passed where the ship Eastland went down, and how where Oprah Winfrey's studio was a makeshift morgue, and you can still hear the cries and the screams there, you know. And so we did all of that stuff.
Well, you know, if you ever want to retire from the Supreme Court and become a curator, there's a museum that might be interested.
Well, we did. We went to the Art Institute. We took them every place. We did all the stuff, and we went to the zoo. We just had a great time. But I did it because, as a gym teacher and a recreation leader, when people socialize together, they get to know each other. And we had to actually work at, like you say, like you asked, we worked together in groups of 4 in our social, but in the groups of the 24, it was less likely we would see each other. We would be passing in the night in the elevator. So in order to get to know each other, I did those kinds of things. It was really such fun.
It's, you know, I think we've all read books about the U.S. Supreme Court, and the fact is a lot of those justices mainly communicate with each other in writing.
Yes. Or they lobby each other, which I didn't know that either before. And
sometimes through their clerks.
Sometimes yes. But I think some of them are somewhat of friends and they see each other, but it's not like the Illinois Supreme Court because...
And then there's the whole Springfield aspect.
Right.
Is it still the case that there's a suite of rooms that the justices
it's pretty much unwritten requirement that we live together on the 3rd floor. The building was built for that purpose. The justices moved in February 4th, 1908. To their rooms on the 3rd floor. Each justice has a room, which is a small little sitting room, a washroom, a restroom, and a bedroom, which is small, but you're not in your room that much either. But we live there, and then we take our meals together. We actually become a family. We know when each other's had a knee replacement, whose grandchild is, ill or playing in a t-ball game.
It's like being in an order.
It is. And we're great, you know, we respect each other, so when the hard decisions come about, and some of the difficult cases where we know that we differ, we can sit at the same table and be cordial.
So what's it like when, you know, so many of the situations that you read about in the newspaper wind up crossing your desk? I mean, that's what it's like being on the Illinois Supreme Court.
Yes.
All these struggles that people read about that happen in other people's lives and in government and so forth, eventually the big cases wind up right in front of you.
Right. It's pretty daunting. It's a daunting responsibility, and I'm honored to be there. Like I say, I'm a very spiritual person, so I believe there's a reason for me to be there, and I have to exercise that responsibility because of that. That, you know, I'm just filling a spot. It's not because I'm there. I have information within me or my life that is important, I guess, because that's why I'm there, to be on that court, and I do believe that, and so I take it very seriously. But it's a very difficult decision. Which case gets picked and which one doesn't, because we pick our cases, as opposed to the appellate court, which is they get whatever they get. They get it all. We can pick and choose which ones, and it's not fair, because if someone writes a petition for leave to appeal, and it's short, it's only a brief description, and I want to know more. It's like it's too hard to pick out. That writing a petition for leave to appeal is an art. Somebody should spend more time, people should spend more time doing it properly, and to catch our attention, because we can only take a certain amount every term.
And I know that in the U.S. Supreme Court, I've read that the equivalent, the petitions for writs of certiorari which come in such large numbers, it's the clerks who really pour over those with the final decision by the justices. Are you reading those yourself?
I can't. In fact, I wanted to slit my wrists. I told Justice McMurrow after my first term, I came to the court in July 2006, and it wasn't until the 1st of August 2006 I started getting these petitions for leave to appeal, in which there was over 500 that we were going to rule on before the second week in September, in addition to the 23 sets of briefs for the oral argument.
We're back with Anne Burke. We were talking about the difficulty of deciding which cases to take, reviewing all those petitions for appeal.
Yes, well, as I was saying, that my first term was in September of 2006, and between the first week in August and the second week in September, I received over 500 petitions for leave to appeal, 23 sets of briefs for the oral arguments that we were to take place, the disciplinary docket for all the attorneys in Illinois, and also the prisoner's docket for cases that were pending, plus all the Illinois Supreme Court committees, the Rules Committee, ARDC, all that information was, I think, an overload for me. I really kind of freaked out because I couldn't do justice to the petitions for leave to appeal, read them all 500. I did divide them up with my law clerks.
How many law clerks does each justice
We
get?
have 4.
4.
And they're very seasoned attorneys and law clerks. I was very fortunate. I was able to inherit 2 of Justice McMurrow's experienced law clerks, and I brought my 2 from the appellate court. So we were a team. I was probably the only one that didn't know exactly what I was doing, but they all did. So we divvied up all the petitions for leave to appeal and hoped that we were able to focus on what we're supposed to. Is there a challenge in the law that is new? Is there a conflict in the law or among the 5 judicial districts on the appellate court that needs to be clarified? Or is the law kind of fuzzy that needs to be clarified? Is there a legislative interpretation that needs to be clarified on these cases? Or is it just one that public policy requires us to look at it? And so with those mandates, that's what we look for. Even if there's something that's clearly wrongly decided, if it doesn't affect more than one person, we just can't take it.
Right. Limited judicial.
And that's what's heartbreaking.
Yeah.
You know, for me, I have kind of a reputation with my colleagues that, with only able to take about 20 cases a term, I have 87 to 90 each time I file. I vote for electronically, allow. But it's hard for me to whittle it down because I think it's important, and I'm just hoping that my other colleagues agree with me. Now, there's another opportunity which I was amazed at and never knew, and I think most lawyers don't realize, that if there's a petition for leave to appeal that everybody's voted against or deny, and I think it's crying out for an appeal, I have the opportunity at our Leave to Appeal conference, which is on the second week of our term, to speak to it at the table with 7 of us. I can argue to my colleagues to ask them to change their vote because we need to take this. In almost every term, which there's 5 terms in a year, in which we're down in Springfield for 2 weeks each term, and that's by Constitution, where I can ask them to consider changing their vote so we can take this appeal. I haven't been able to do that in a long time, to be an advocate for something.
Well, so in a way, you're having a rehearing in Bonk, but with your own colleagues.
Yes.
But I imagine that's not the kind of argument you can make willy-nilly. You've got to choose those battles very carefully.
Oh, absolutely, because then they won't be. They won't change their vote if I keep on doing it. But I mean, it has to be something that I really feels will affect more than one person. The law has to be clear. It's all fuzzed up, and we need to do something about it. And my colleagues do the same thing. They have cases in which, and I generally go along with it because I don't see the reason why we can't. You know, what difference if we take a couple more cases? I think if we should. It's more difficult to get it all done by the next term, but get a good decision out. But I think that's our responsibility.
Now I remember from appearing before the Illinois Supreme Court, what always astonished me was how long your hearing days are.
Oh, yes.
They begin first thing in the morning down there in Springfield, and they go forever. And I really don't know any other appellate court that operates that way. What's it like?
It's grueling, but we do get up if we have to go to the restroom or take a cup and just move around a little bit. I know it's disconcerting to a lawyer's arguing when somebody gets up in the middle of the oral argument to leave, but we have video in the back and also audio, even in the restroom, so we don't miss a beat if we're in the back just taking a few minute break. But yes, it's generally from 9:30 in the morning until whatever time it takes. We take a break for lunch, and that's what our job is. Though it's 2 weeks together. It's the best way to work because we're all there together for 2 weeks, except for the weekend in between. We get all the work done of the court. The rule is we leave our impression room that's behind the bench, and we do not talk about the cases. We do not talk about it at lunch, breakfast, or dinner, or on the phone, or anything like that. That's only for the impression room, period. And we circulate opinions. The recorder of opinions circulates them at the same time. Any suggestions or memos to each one of us goes out at the same time. We all get it at the same time, so there's no question what we said or how we said it or which line and which page needs to be addressed in this case. So, and who said it. So we can all look at it together.
And it gives you tremendous writing responsibilities as well.
Oh, yes.
Apart from the hearing responsibilities,
a lot of reading.
You're a sitting justice. We can't talk about the actual cases, but we can talk about the methodology a little bit. How do you work with your clerks? What's the workflow like, if we can spend a minute or two?
Sure. Well, for petitions for leave to appeal, as I said, I have to divide the 400 to 500 up. I do have my priority cases that I want to see all of the minors cases, no matter what it is, myself. I have to see all of those myself. And we divide it up, and they have they mark each one as a recommendation. I go through them all. I don't read them all, but I look at every single one of them and determine if it's a deny or it's an allow, and I review them. So, and especially the denies, I look at a lot more.
Then the actual opinion writing.
Then it comes to opinion. There's 7 of us on the court, and there's a grid, 1 through 7. And the grid is followed to and adhered to perfectly, 1 through 7. If you're number 6, then number 7 will be getting the first case next term. Mm-hmm. So, and that's how it's all assigned. Then, once they're assigned, we go through our own recusals. For reasons I could decide I can't be on this case or I can't, but that's taken very seriously because there's only 7 of us, and if one of us recuses, then there's a possibility of a 6-6. And in the rule of necessity, we haven't had to apply yet, but very rarely